Well, it is about that time we are going to be speaking this morning with attorney Jules Martin Haas. And we're always excited to speak to Mr. Haas because he has some information that is so relevant to everybody, because at some point in time people die, and while they're alive they don't think that they're going to die, and they don't make a will, they don't have any kind of preparation, and when that happens everything gets very chaotic because the intestate laws come in, and in fact, let me just put you on to the professional himself, attorney Jules Martin Haas. Good morning.
Good morning, Trevor. How are you today?
I am doing just great. Just chatting about your specialty, wills, trusts, and estates. You know, when you ask people about wills, trusts, and estates, they go, what is that? Until it hits them in the face when something happens, they don't realize how significant this is. And I just wanted you this morning to give them an idea of just some of the things that happens when, you know, people die without the will, or people separate, and, you know, how many, you know, different types of kids, I guess, they you know, the court recognizes, you know, I think, and I don't know, I'm just speculating so you can straighten all this out. When somebody has outside kids, the court doesn't look at that as an outside kid, right? It's just one of the person's children. That's it. Is that how it goes?
Okay, well,
you unravel it.
Well, there are, you know, innumerable problems that arise when a person dies without a will. The first issue that arises is, you know, who the person's heirs are. You know, who are their next of kin? Because these are the folks that are going to be entitled under the law to inherit the estate. And the main problem that you encounter when you don't have a will is that the person doesn't have the opportunity, as they would if they wrote a will, to delineate and state very clearly who they want their property to go to. What happens is they're sort of stuck with what the New York statute says, and the statutes provide a list of priority of who inherits. And that priority list starts with the spouse and children, and then moves down, if those individuals aren't alive or not, not in existence, to parents, then brothers and sisters, and their descendants, such as nieces and nephews, and then you get further down to cousins and first cousins and thereon. So that always presents a problem because the statute may not necessarily reflect what a person's desires would be. Their desire may very well be that they want to leave their estate to a friend or someone else other than the person the statute requires.
And you can't do that. You can't leave it to a friend if you wanted to.
You can if you write a will. But if you don't write a will, that friend's not going to be part of the statutory scheme, and so they would be left out. You have to go according to what the statute requires. And you had mentioned an issue with respect to children. And, of course, that always presents a problem because even though a spouse and children are right up at the top of the list of who would inherit, when you are trying to figure out who next of kin are, the law states that a person that descends from their mom, well, that's easy. You always know who the mom is. But in a lot of situations, you have people who are offspring of dads who were not married to the mom at the time the person was born. And there's no presumption of kinship from your dad if you were born and your parents weren't married. So what ends up happening is that you end up having to prove, according to the statute, that your dad was actually your dad, so you can inherit his estate. And sometimes that can, and the statute gets very particular. There's different ways of proving this. Through genetic markings, you can do that. There's a sort of a basic provision in the statute that provides where you can look to see if the dad openly and notoriously recognized the person as their child. So the bottom line here is that when you don't write a will, just from the little bit that I've been talking about, you can see how complicated it can be for the survivor, the surviving child, to prove that the deceased dad was actually their dad, so they would have a right to inherit.
Wow, it could get very complicated if you don't have a will. Very complicated, because you are just going through the people who are concerned, who are in line for this inheritance, and then you have all these other problems that come up, plus the law, plus they might have to do DNA. It could get very nasty after a while. This could go on for months.
Trevor, it can go on for years. Unfortunately, and it does get nasty, because obviously what ends up happening is that you have other people who are involved in the estate. And, of course, when somebody passes away, it's amazing, but, you don't think about it, but somebody passes away, they own a house, they own some bank accounts, they own some retirement funds, and lo and behold, when you add all that stuff up, you're talking about an estate that could be easily over $1 million, particularly with the rising real estate values these days in Queens and Brooklyn particularly, because I have a lot of estates in Brooklyn. The property values are sort of crazy. And so you've got other competing potential heirs who obviously have a financial interest in eliminating other people that would share in the estate. And the court has very strict requirements before they will allow an estate to be distributed to a person claiming to be an heir, because the court wants to be absolutely certain that they don't have someone coming in here trying to get an inheritance that they're not entitled to.
And not only that, you have other people who probably in the last days of the deceased took care of them, and they feel like they have rights too, but then all that is a wash, because I don't think the court factors that in. The court just looks at the lineage and the procedure that, is it called the intestate laws that govern this kind of activity?
That's right. When you die without a will, the intestate laws go ahead and control who the next of kin are. And that's in the, without getting too technical, the estate powers and trust laws in New York. And they're very, very specific as to who can inherit. You also have a problem sometimes in determining who the next of kin are as far as lineage, because if someone is at a level of, let's say, cousin, first cousin, second cousin, or something like that, or first cousin once removed, then, you have to create family trees. And when you have people whose descendants are spread out all over the country, or possibly all over the world, you have genealogists that have to go ahead and do searches. I just had a case where it was a probate, but we still had a kinship issue, and the family came from Ireland, and my genealogist did a report that was 50 pages long with 250 exhibits.
Oh my God!
of birth certificates and death records to show the family heritage.
Folks, listen, I guess I gave you a big challenge in trying to even unravel just the preliminary part of it, and it's so complicated. I could see why you say it goes on for years. Let me just do this, because people are interested, but we can't figure this all out on the radio. You got a taste of how complicated it could be, folks. So if you have property, if you want to not have chaos on your demise, pick up the phone, call attorney Jules Martin Haas. His number is 212-355-2575. 212-355-2575. Now, he has a blog that he does on his website. Every week you do a blog, right? Is that how you do it?
That's correct. I write an article every week with just basic information about, estates and guardianships, and it's very informative. It's basically informational, as is the website, with hundreds of pages of information.
Could you give us the website again? It's Jules Martin.
Sure, it's JulesHaasAttorney.com. And if you go to Google, all you really need to do is type in my name, which is Jules, Jules, Haas, Haas. And if you do the Google search, it'll take you right to my name, and you can just click on, you'll get to my website.
Okay, I'm going to do that today because I want to be more informed about this. But I really want to thank you for, getting up this early and talking to the folks who are commuting to their jobs. And they have to think about this. This is very, very important stuff. Again, attorney Jules Martin Haas. His number is 212. This is an easy way to get to him. 212-355-2575. 212-355-2575. I'm giving you that nice and slow so that you can punch that into your cell phone right now. And what should they put? Should they put Jules Martin's Haas, or should they put wills and trust? I don't know. Whichever way is easy for you, but the best way to do is put that number down, 212-355-2575. Thank you very much for joining us this morning, sir. I really appreciate that.
Thank you very much, Trevor. You have a wonderful day.
Great information, folks. Great information. Attorney Jules Martin Haas. 212-355-2575.